told to go back, and he went back. So there's no flight risk at all. Consequently, based on those facts, there is no grounds for being involved. Before I forget also, the aspect of the DNA. We had my client for 16 days. His DNA profile won't change. If they need him to appear before any DNA lab, he'll appear. An application I'd like to make to the court. When the police went to his home, the stuff they took from his home, they haven't given him an inventory. So I'll be asking for him to give an inventory of all that they took from his home. So that at the time of his release, he can be able to get his stuff back. I'm also making an application to the court to release motor vehicle KCR 77Y, which he drove himself.
KCR
771.
77. Those are
777.
Yes.
Which is at the station. He drove himself there. It's not part of the exhibits that have been detained. It's him who drove it there. The family is being forced to lease motor vehicles or rent out motor vehicles to use. Yet that vehicle, if you look at it at the moment, because I was there yesterday, it's deteriorating. Yet it's not part of the investigations that have been conducted. So we're making a humble application that that vehicle be released to the family so they can use it. And I had also forgotten that the kids are out of school.
Yes.
Thank you. So we can deal with the aspects of the authorities. Many other things we tend to rely on.
All right. Mr. Morioki.
Yes, Your Honor. We are opposed to the application by the investigating officer, Your Honor, for the simple reason that it is unconstitutional and illegal. Under Article 49(1)(a) of the Constitution of the Republic of Kenya 2010, it is a fundamental right of the accused person.
Not yet an accused person.
Yes, the proposed accused person.
Yes,
the
suspect or
yes.
respondent.
Yes.
Yes.
Yes, so correctly. To be informed of the reason for his arrest, during his first appearance in court. Your Honor, this already happened. And there being no holding charge that was preferred against the respondent, the first respondent, it is manifest that the charges he's likely to face are not yet known to him in clear breach of his fundamental rights. Your Honor, this position has been held very firmly by Justice Luka Kimaru in High Court Miscellaneous Application number 304 of 2016, the case of Michael Rotich against the Republic. The facts in this case are on all fours. And it is our humble submission, therefore, that an illegality should not be perpetrated by the investigating officers in the name of finalizing investigations. now have a copy of the authority for the court.
Yes.
And the last issue that we wish to raise, Your Honor, is that there is further illegality carried out by the investigation in this case, in failing to expedite their investigations, so that the first respondent's right to a speedy trial is being militated against by the further 14 days that the investigation is lasting. Now, if I may delve just briefly into the facts as laid out by the investigating officer, is that at paragraph 4 of his supporting affidavit, he says that the case was taken over by the Homicide Division on the 11th of February 2019. That fact, Your Honor, supplies adequate time for the procuring of all DNA samples that the investigators would have required. The first respondent was in custody. Let them not make out like harvesting of epithelial cells from the inner cheek of the accused person, something that would require more than 2 minutes, so that it should have been done on the same 11th that they received the instructions. And further, Your Honor,
Don't do that again. Yes. Yes.
the intended areas of investigation,
Yes.
as listed in paragraph 5 of the supporting affidavit, is to lay it out: cybercrimes unit, ballistics, photography, and the government chemist. It's clear as day that all these are institutions within the DCI or other external government agents, where clearly the respondent has little or no sway at all in terms of influencing those areas of investigation. So we humbly pray that this court does find that the further 14 days sought by the investigating team are unwarranted and, most importantly, illegal. We pray that this court does not help them, the investigating team, in breaches of the law as blatant as this.
An application had been brought in this court to hold the suspects for 14 days. And PC Cornelius Araswa swore that affidavit. In that affidavit, he had asked for a few things to be done so that the 14 days that he had asked for seemed to be sufficient. 14 days later, Inspector John Wahome swears another affidavit and starts asking for the same things. Initially, they had said they wanted the suspects in custody so that they can be able to do mental assessment, so that they can be able to take their DNA, so that they can be able to recover exhibits, so that they can avoid interference with investigations. Apart from that, they spoke of CCTV footage which was to be retrieved and call data from Safaricom and Airtel. The second affidavit is the same thing that this officer is also asking for. So in the next 14 days, we will come back here again and they'll ask for another 14 days because they are doing nothing. And as they continue doing nothing, Your Honor, the fundamental rights of the accused persons, I mean the suspect in this case, keep on suffering. They are being trampled on. You cannot allow that today, Your Honor. Not today, not ever. Why would they require the suspect to go to Safaricom and Airtel? Why would they require them? Because my client, the second respondent, does not work in any of those organizations. So it would be unnecessary to hold up for that purpose. Why would they want the second suspect to be held because of CCTV footage? It is not hers, she did not provide that service, and therefore they do not require her for that CCTV footage. Mental assessment does not take 14 days. All they need to do is take the suspect to the station or to the Madari Mental Hospital in the next 1 hour, and that will be done. So we can finish that problem today, here and now, so that the 14 days you can see are totally unreasonable. Then they are telling you that they also want to have the accused person take the DNA, which is not a problem. If they came and took her blood sample right now, or did swabs, that can also be done here and now, 5 minutes. All they need to do is bring the kit here, and that can be done. So now let us look at the 14 days they're asking for. Is it fair? Can it be looked at as reasonable? They have already had the 14 days, and they have done nothing yet. Another 14 days? It cannot be fair. Your Honor, these accused persons have fundamental rights.
Not yet accused.
Sorry, every time I'll say accused person, if I forget, please just put it responded because.
Yes.
Your Honor, these respondents have fundamental rights, and these fundamental rights are in the Constitution, and they are not there in vain. In as much as they are there to protect the victim under the Victim Act, but they are there mainly for a person who has been arrested. So how many days have these suspects been in custody? I will not even say 16, I will say 18. Because the second respondent was arrested on the 27th day of January. They even have had extra 4 days that they would have done what they wanted to do. Extra 4 days. But Article 49H says one thing, that when a suspect has been brought to court, he is entitled to bond unless the prosecution have what you can call compelling reasons. So far, I have shown you what they are bringing as compelling reasons, and you cannot consider those ones to be compelling reasons. So when they fail to give you compelling reason, then this right becomes absolute because they have failed. Then now the rights of the suspect must then be observed. So today we are asking, please release the suspect. Do not punish them longer because of the mistakes of the police. And they are my friends, though sometimes I don't like them. But then, on a day like this, I will not like them. When they come for 14 days, honestly, I will not like them. But prior to that, they are my friends, and they know it. Wahome knows it. Apart from that, Your Honor, if then under Article 45, when we have come to this court, and you find that then our fundamental rights are not being then addressed, then we come to Article 19. And Article 19 is one of my favorites, and it's a very simple one. It says that these fundamental rights, they do not belong to anybody else apart from an individual. They do not belong to the state. So the state comes here today and they throw affidavits at you, 1, 2, 3, and they're not going to stop unless you stop them. They're going to keep on throwing these affidavits to you. And then they are asking, please keep these people. For what purpose? So Article 20 says then all state agencies, all state bodies, including the court, the police, the prosecution, must then observe and notice that these fundamental rights do exist. And once they notice that these fundamental rights do exist, then it brings us to Article 21, whereby when you are starting to notice that they are there, you must start by wanting to grant. You do not start by starting to object. And this is what they have done. When they bring this affidavit, they are objecting. They are not being fair. They are not starting on the right footing. So here we are coming to your honor, because you are the only one who can save us from these clutches of these very good friends of mine. Article 22 then comes in quite clearly now. When we realize that now they do not want to grant us our rights, what do? We come to court and tell you that what they are doing is wrong. And honestly, my colleague here knows that if he touches his own heart, he knows that what he's doing is not very right. But then, once we have come under Article 22, it pushes you to Article 23, whereby now you take the initiative and grant us our rights. Apart from that, they should be able then also to grant the suspect some kind of dignity. And Article 29 is clear on that. They must be able to grant them some kind of dignity. Actually, it's Article 20, sorry. Why am I bringing up this issue? Initially, the second suspect made a statement to the police as they were investigating this matter. Thereafter, Your Honor, and this is not your problem because you observed the law. You did what you were supposed to do. You granted them few days, these 14 days. What did they do with the 14 days? They used them for the purpose of abusing the second suspect. We had written a letter, Your Honor, you can notice on the file, there's a letter we wrote requesting that the matter be mentioned. The suspect has been tortured. I'm not embarrassed to say that. Let me say so that I can say the graphics equally. She has been tortured. And if she was to remove this top of hers today, if she was to remove this trouser that she's putting on today, you will see the marks. She has been tortured. Not by one officer, but various. Friday last week, she reported to the OCS of Juja Police Station.
Friday,
That was
last week.
Last week.
That would be the
9th.
It's 8th.
Yes.
Yes.
She reported to the OCS at about 7 p.m. in the evening. She had been tortured. The investigating officer handed her over to two police women, police ladies, let me call them ladies, at least let me respect them now, and who now then took her up. White and black, let me say that they had to even insert these chilies, the green ones, inside her private parts. They inserted. She complained to the OCS. What has the OCS done about it? Nothing. So the 14 days that you gave the officers to use, they are using it for a different purpose. Not to investigate, but to force confessions. Not only to force confessions, to ask her to change her statement. I don't know in whose favor, but to change her statement. She has refused vehemently because I told her, do not try that. So when they're asking for 14 days, Your Honor, are they going to use these 14 days to do more harm on her? Because whatever they've asked you for is not reasonable. Is it going to do more harm on her? She's even afraid to go back to that police station so that in case, and I'm hoping you do not grant them the days. In case you grant them any days, we cannot go back to that station. First of all, because we have reported. Secondly, now we have caused enemies. So she's not going to go there in a friendly turf. She's going to go and face the enemy on two issues. What she has reported and what they want to do. Please, Your Honor, you are the only one who can save her from that problem. In this affidavit, you are also being told that now the suspect will interfere with investigations. And you are also being told, apart from interfering with investigation and witnesses, she also is likely to abscond. What does the law say about that? He who alleges must prove. So when they say she is going to abscond, what material have they placed before court to show that she is going to abscond? Has she made any attempt? Has she made any preparations? Has she bought any tickets? Something at least, so that when they say that she's going to abscond, you must then be able to know that it is true. But when they tell you that, and we say she's not going to do so, who do you believe? The fundamental rights must start with granting to the suspect. So therefore, you will have to believe us. Then they tell you that she will interfere with witnesses. They need to tell you, has she done so? Is it direct or indirect? Has she attempted to call any of the witnesses? But then the question will be, does she even know who the witnesses are? We do not have the bundle, you do not have it in your file, then who are these witnesses? In the absence of any proof of that kind, Your Honor, you must start by granting the bail we are asking for. And they are saying in paragraph 12 of the affidavit that they require sufficient time to compile and forward the file. 12 of the affidavit, the new one. They are saying that they require time to compile and forward the file to the ODPP. She does not work for the police. She does not work for the DPP. Why do they need her to do that, to compile a file? Is she going to write for them? Are they illiterate? They can be able to do their work without her being there. But then you're being told in paragraph 13 that the continued detention of the respondents will assist investigations and balance the rights of the respondents and the victim, who is the former. How do the rights of the victim outweigh the rights of the respondents? What kind of reasoning is that? Where did it even come from? It has no precedent. It is imagined. They cannot come and tell you such kind of things and expect you to believe. Your intelligence is much more than that, Your Honor. Let them not even try to do that. Your Honor, why you have said all that? In the absence of them giving you any evidence, in the light of the complaints that have been made by the accused person, isn't this a right person to be granted bail today? My argument is yes. So that she can go and seek treatment, so that she can go back home where she stays. Her house has been locked all this time. Actually, she doesn't even know it's locked. She has got a family. She has got a son. He's 5 years old, who is even not going to school right now. But they still want 14 days, and this boy still stays at home. Look at the remoteness of it. The damage to her is not only to her, but also to her children, to her son and her family. She is the sole breadwinner of this family. So the moment she stays inside here, apart from her fundamental rights being curtailed, everybody else around her suffers. Probably I might mention that once she gets out also she may be able to get my instructions. But that
Mr. Umbeta, that's your business with your client. Yes.
Yes. So give her time to give her bail terms. And I'm saying this under Article 49, it says that there must also be terms that she can be able to meet. She's from a very humble background. She has worked her way through all this that she has managed to attain until this particular moment. Give her conditions that she can be able to meet, even if it's a reporting order, even if it's to deposit her travel documents, even if it's to report to this court on a daily basis or on any other day. And finally, we would also ask that they release a motor vehicle which they are holding at the station, which has nothing to do with this case. A motor vehicle KCR 898L, and Mercedes Benz. That is all I wish to say.
Okay.